One of the biggest mistakes I see is in TBI cases is attorneys telling the story in the wrong order. So let's talk about why sequencing matters in trial and in life.
TBI cases can feel like navigating uncharted territory. Your client's injury is real, but proving it, that's where the real challenge begins. If you've ever felt like you're missing crucial pieces of the puzzle, you're in the right place. Welcome to Winning the TBI Case, where Tom Crosley shares the insights he's gained from over 60 injury trials. Not just the victories, but the lessons learned along the way that make all the difference. This is practical wisdom from someone who's been in your shoes and found a path forward. Winning the TBI Case. Strategy, science, and storytelling. Let's join Tom as he shares powerful real-world examples from his own cases, showing how proper sequencing transforms skeptical jurors into believers who are conditioned to see the injury rather than question it.
Welcome back to Winning the TBI Case. I'm your host, Tom Crosley. We're going to talk about one of my favorite subjects, and that is how to effectively sequence the evidence for maximum effect in a trial, and in particular in a TBI trial, because it's different than it is in most cases. It's all in the sequence. And so for the next few episodes, I'm going to walk you through how I try a TBI case using what I believe to be the most effective sequence, a strategy I've honed over years of litigating these cases and sometimes winning big, very big for my clients. We'll talk about the biggest challenges that trial lawyers face, how to prove what's often called the invisible injury, and how to keep jurors engaged in highly technical medical testimony, and how to counter the defense's favorite argument that your client is just making it all up. So I've seen what works, I've seen what doesn't work, and most importantly, I've seen how jurors think and react. And one of the biggest mistakes I see in TBI cases is attorneys telling the story in the wrong order. So let's talk about why sequencing matters in trial and in life. So let me ask you something. Have you ever watched a movie where the twist at the end completely changed how you saw and reacted to everything that came before it? Of course you have. Think about Alfred Hitchcock's Psycho movie, the famous 1960 movie with the shower scene. Everybody knows the shower scene. Early on, we think Norman Bates is just a twitchy guy with an overbearing mother. But Hitchcock carefully controls what we know and when we know it. The result, suspense, engagement, and ultimately, one of the most famous films of all time. So trying a TBI case is a lot like that. And what I mean by that is the order in which you present your evidence changes how the jury will perceive your client, your case, and ultimately your verdict. So I tried a case recently within the last 12 months, and a lawyer in my firm had done most of the work, and we're getting ready for the trial. We've got 22 witnesses in the case, maybe 24. And I had him put together the list of witnesses and the order that he thought they should go in. And the first witness he had was the plaintiff. And I said, let's consider not leading with the plaintiff. Because in a TBI case, I think it's the wrong approach to start off with the plaintiff. Sure, maybe the plaintiff could tell the whole story. They were in the crash, what happened after that, when they went to the doctor, how everything's been since then. But if you do that in a TBI case, you're probably losing. Let me explain why. When lawyers start the TBI case with the plaintiff on the stand, they figure, hey, let's get the jury to see and hear from our client so they can sympathize with the client. It sounds logical, right? Wrong. So most TBI clients, especially those with so-called mild brain injuries, they look normal and they sound normal. No head bandages, no slurred speech, no visible scars. So what happens? Jurors see that person and they think, well, they look fine to me. So why are we here? They claim there's a brain injury here? I'm not buying that. This person looks just like the juror sitting next to me. That's the problem. That's the fundamental problem we have on these cases. So what is the right approach? Well, the right approach means you've got to have convinced your jury that your plaintiff has a brain injury before your jury ever meets your plaintiff. So how do we do that? We start with the science and we end with the emotion. The key is controlling juror perceptions from the very beginning. You want them to see your client's injury before they ever see your client. How do you do that? By sequencing your evidence like a master storyteller. Starting with science, before the jury meets your client, they meet your expert witnesses. Probably the neuroradiologist who's going to show them the high-resolution advanced brain scans. Maybe the blood deposits that are still findable within the MRI 2 years later. The neuroscientist who's going to explain what happens when the brain smashes within the skull in a car crash. Maybe the treating neurologist who explains why these injuries don't just go away on their own. When jurors see objective, undeniable proof that something is wrong, it changes the way they view everything that follows. They're going to now view all the remaining evidence through the lens of not, I wonder if this is real. Now that they've seen the objective evidence from your neuroradiologist, they're going to view the rest of the evidence through the lens of this is real. We call it confirmation bias. When you already believe or are nudged to believe one thing, the rest of the data you look at tends to support your early hypothesis. So let's do that with brain injury cases when we try them, starting with our key, most irrefutable evidence. Now remember, let's not put the cart before the horse. You've always got to start your case with liability, negligence, why the other side is responsible for whatever it was that happened. Because who's ready to listen to evidence in a case about what the harm was before they know somebody else is actually responsible for the harm? The ears of a jury aren't completely open to hearing how much the defendant should pay for damages until they first have learned why the defendant is legally responsible for that harm. So we lead off with liability, but when we do get to damages, when we do get to harm, we start the brain injury part of the case with our most irrefutable evidence of brain injury, objective evidence, evidence that can't be faked.
If you're finding value in today's episode, here's how you can take your TBI practice to the next level. Subscribe to our newsletter at crosleylaw.com/podcast for exclusive case studies, resources, and trial strategies you won't hear anywhere else. That's crosleylaw.com/podcast, or click the link in the show notes below. Don't just listen to the strategies, implement them.
All right. We're also going to build the case around before and after witnesses. The more, the merrier. I usually want to ask to interview 15 of them and end up with 7 of them that actually testify in trial. They're short witnesses, 10 or 15 minutes each. But once you've given jurors the medical foundation, you introduce people who can tell them in human terms just how different your client is now. The best before and after witnesses, their family members, their close friends, their coworkers, could be a boss, could be somebody on their softball team or their recreational league, the mailman, anybody that they knew and interacted with on a regular basis. Because those people who knew the client before the injury can say, hey, this isn't the same person anymore. And then I'll usually have those folks give us a story or an example. Here's one from one of my cases. And I had a bunch of them because I had a bunch of different witnesses come in, each with a story. And remember, a story is way more powerful than saying, oh, John doesn't think as quickly anymore. A story telling how John doesn't think as quickly is far, far more important. So in one of my cases, the client was going to like a family reunion at a community park. And he got lost on the way there, but he'd been there before. He got lost and he had to pull over and call. And then they explained where he was supposed to go. And then he got lost again. And this was pre-Google Maps. And so ultimately, the guy who's on the witness stand telling the story, he said, okay, where are you? At the Shell station? Stay there. I'm going to come get you. You can follow me to the park. It was powerful. That was just one example. But every witness who testified in that case had an example. Another was about a time the brain injury victim, because he was not able to control his emotions very well, had gotten in a fight with his wife, sat in the truck of his car in the driveway all night long by himself. Who does that? And she'd been married for 20 years. This had never happened before. In a brain injury case, before and after witnesses are proving the existence of the injury. It's weird, right? In a physical injury case, a before and after witness is helping you to prove how the injury has affected the person. In a brain injury case, the before and after witness is actually proving the existence of the injury, because that's the nature of the brain injury. It has changed the brain in a way that changes their function, their behavior, their moods, all these things that we'll talk about in future episodes. So don't try a brain injury case without effective before and after witnesses. Do find as many as you can get. Do vet them and pick your best 5 to 7 and give everybody a mandate that they show up to tell a story. What's next? You got to strategically introduce the plaintiff in an effective sequencing of a TBI case. So how do I do it? I video the plaintiff's deposition. If the defense lawyer doesn't, I do. And during the course of that 3-hour deposition, my plaintiff will invariably forget what the question was when giving an answer. We'll pause and say, I'm sorry, can you repeat the question? Or sometimes they'll get mad. They'll yell at the lawyer. They have emotional volatility. Sometimes they will cry. Sometimes they'll forget stuff. I had one lady was asked where she went to high school, and she forgot where she went to high school. And then about an hour later in the deposition, she blurted it out, where she went to high school, a question that she was so frustrated she couldn't remember from before. So what did I do? I made 45 to 60-second clips of those things. The jury had not met the plaintiff yet. They'd seen a picture of her. And with each of my expert witnesses, I would play that 45 to 60-second clip, different one for each witness. And I would say, I'm going to show you a clip, and then I'm going to ask you some questions about it. And then the question was invariably some variation of this theme. Dr. Expert, what was significant about what we just saw? Oh, well, that's classic TBI. That's somebody who can't control their emotions anymore, or fill in the blank. But what I've done, it's not so much to try to find out what the expert's opinion was. It's a subtle way of introducing the plaintiff to the jury long before the plaintiff ever shows up in the courtroom in person. So that by the time the jury finally does meet that plaintiff who testifies toward the end of the case, the jury has already reached the conclusion, we hope, that, wow, this person has a brain injury. Instead of, I'm not sure. She looks normal to me. So that's why sequence matters in this kind of case more than almost any other kind of case. Now, after jurors understand the injury is real, we bring in the client. And by now, they're primed to notice the subtle signs of brain injury, the hesitation, the forgetfulness, the emotional outbursts, things they may have dismissed or not been tuned into had that plaintiff testified first in the case. Now, finish with a strong emotional punch. This is true in almost every case, but we have to end in a TBI case with a final compelling witness who can speak to the deep emotional impact of the injury. It could be a spouse. It could be a parent. It could be a child. Sometimes an adult child, or even an adolescent, 17-year-old child who says, this is not my dad anymore, can be really impactful. In fact, I can still feel it from a TBI case I tried about a year ago, because that's the witness I ended with, which was one of the 4 sons. And I was trying not to cry while he was testifying, because I don't want to look like I'm acting in front of a jury, but it was real and it was emotional. And so find your most compelling witness and figure out how to end with that person, because you want to leave the jurors not just understanding the injury, but feeling it. And so maybe it's a best friend who describes how the plaintiff used to light up the room, but can now barely make it through a conversation, who used to love to go out with the guys on Friday night, but now just prefers to stay home with his headphones on. Who knows? But if you get to know your client and you do all the before and after interviews, you'll find the stories, and it'll be like digging for gold. So now let's put it all together. Think about it like this. If you were introducing someone to a great band, you wouldn't start with a deep cut off their latest album, right? You start with the greatest hits, the songs that prove why they're great. before you ask for a deep dive. It's the same with the TBI case. Start with the biggest, clearest proof of injury before introducing the nuances. Start with the greatest hits before going into the deep dive. So in one of the next episodes, we'll get into the science of TBI and how to use expert witnesses to build credibility early and shut down defense arguments before they even start. I'll give you my playbook for selecting and sequencing expert testimony that keeps the jury engaged and makes the complex science stick. Until then, remember, it's not just what you prove, but when you prove it. Get the sequencing right, and you're halfway to victory. This has been Winning the TBI Case. I'm Tom Crosley.
If today's episode helped you see your current case in a new light, share it with a colleague who's facing the same challenges in a case. Subscribe wherever you get your podcasts and join our community of trial lawyers who refuse to settle for average results. This has been Winning the TBI Case. Strategy, science, and storytelling with Tom Crosley.